27 versus GSCO Infrastructure Private Limited versus the State of Finance for Education.
Maybe. Lords, application for causing the communication lords contained under annexure. Annexure 1, lords 2 and 3, lords whereby lords the work which was awarded to the petitioner lord had completed. Completion certificate lord was issued. Entire payments were made. Now, my lords, after a lapse of 1 year, a complaint was filed by a local a member of the Legislative Assembly. On that basis, my lords, some inquiry was held behind the back of the petitioner without informing. Now that inquiry report says that some excess payment was made and some irregularities were committed in course of construction. Then even at that stage, no notice, no hearing was given, and lords, the department directed the engineer, executive engineer, to recover rupees 5 crore 87 lakhs and odd. And
what is the mode of recovery?
My lord, what has happened, my lord, is that at the stage when this writ application, my lord, was filed, we prayed for causing of that communication. During the pendency of this writ application, out of 5 crore 87 lakhs and odd, my lords, they have recovered 5 crore 50 lakhs from the earnest money which, my lord, petitioner had deposited in the shape of bank guarantee.
No, that was not settled for 1 year from the date of completion of work.
Yeah. They had not refunded that. Now, my lords, by bringing an IA, we have challenged that part of the order also, and my lords, on earlier occasion by order number 3, my lords, the on-board court by a detailed order, my lords, allowed the IA application for amendment, my lords, and further directed, and my lords, simultaneously proceeding was initiated against the executive engineer, assistant engineer and junior. And in that proceeding, my lords, all of them have been exonerated of their charge. So on one hand,
No, what is the reason for recovery?
The lords, is that excess payment was made and some work were not as per the specification.
Arbitration is not there?
No, that was not resorted to. Neither, my lords, at any point of time I was informed.
No, is there any arbitration clause?
There is a arbitration clause, lords.
Then invoke arbitration.
But, my lords, my recovery of 5 crore 50 lakhs without any hearing.
No, we will set aside and permit the respective party to invoke remedy under arbitration.
My lords, they can, but so far my recovery that has been made,
that will be decided by the arbitration.
My lords, that may be decided, but the recovery at this is
not a small amount, sir, 5 crore.
So that, my lord, they should restore that amount because it was.
No, thereafter, if you are liable.
My lord, I will the bank guarantee, my lord, is here. I will keep that bank guarantee alive.
Where is the arbitration clause?
Page 133, my lord.
133.
Clause 25.
Oh, bank guarantee.
It is there. Sorry. We really remand the matter to the arbitration. You go and invoke.
What my lord said, to that extent, what I am respectfully
or whatever it may be, sir.
But my lord said, when the work at no point of time, the certificate, my lord, of the executive engineer is here that the work was completed to full satisfaction. Even, lords, we have brought on the record.
Sorry, sir, we will not. Yes, take down.
And my lord, this court by order dated order number 3 consider all these aspects. Even my lords, the plea of alternative remedy was considered, and that was
The dispute in respect of non-performance of duty and withdrawing certain money.
no. But my lords,
That is the issue.
so that is
Ah.
my lords can.
That is required to be settled by in arbitration.
But my lords, this part, that part is concerned. The amount is with. It is.
Sir, if you succeed, you will get along with the interest.
Lords, so to that extent, lords, they should. Otherwise, lords,
They will invoke arbitration clause.
lords, my
Or
amount,
their claim 5 crore, you also invoke EMD for refund.
lords, so my amount is for 1 year they didn't refund. They ought to have refunded.
Sir, claim interest, sir, before the authority,
But lords,
before the forum.
lords, I pray that my lords may direct them to refund the amount,
No.
and within 2 months or 3 months arbitration should be done.
No. Yes, take note. In the instant petition, petitioner has prayed for the following relief. The respondent,
Lords, so
respondent should.
beg your pardon. Then the order which was passed, which I have challenged by bringing an IA, that should be quashed to that extent. That order should be quashed.
Yes.
Because ultimately they will take, they have already recovered, they will recover further, then they are also threatening to lodge criminal case.
Yes, take down in the instant petition, petitioner has prayed for the following relief. So petitioner is a contractor who had been assigned certain works which were stated to have been completed. However, despite the fact that the work has completed, the respondents have proceeded to recover a sum of rupees 5 crore 87,73,977 from the petitioner. On the score that petitioner was allowed to draw certain amount, the absence of execution of certain works at a relevant point of time. So, these are all disputed issues which are required to be settled in the arbitration in the light of clause 25 of the agreement. So clause 25 relates to settlement of dispute and arbitration. Accordingly, the impute action of the official respondent is contrary to clause 25 of the agreement. Therefore, the petitioner has made out a case. Accordingly, it is set aside, and the impugned orders so and so are set aside,
And it's certain.
reserving liberty to the concerned official respondent to invoke clause 25 of the agreement for in respect of settlement of dispute and arbitration at the earliest, since petitioner's EMD amount is lying with the official respondent to the tune of about a sum of rupees 5 crore.
50
5 crore?
50 lakhs.
50 lakhs. So, the arbitrator, jurisdictional arbitrator is requested to decide the arbitration case in the event of filing arbitration within a reasonable period of time with the above the petition stands disposed of.
Lord, that order is unaccepted.
Senior number 38, Rajiv Kumar Singh versus the State of Bihar for the petitioner Sri Manish Kumar number 13.
Policy decision of the state government below is under challenge.
What is the locus of the petition?
So that is the prime issue below. It does not have any locus below. The local self-government is there below. We have transferred those powers to them below.
None appears for the petitioners. Prima facie, we find that petitioners have no locus to assign the impugn decision of the state government. First, in order to give one opportunity, release this matter after 2 weeks. First, if there is no representation on behalf of the petitioner, matter would be decided with the available records. Is this matter?
Right.
Senior number 39, Mrs. Jama Durga Travels versus the Union of India for the petitioner Sri Varun Kumar Jyoti.
My lord, I pray for 1 week time, my lord, in this case.
Huh?
Also, the counter affidavit has also not been filed by the respondents.
You have approached this court insofar as questioning the termination notice. How writ is maintainable? During pendency of the litigation, have they passed order? No, or you don't know?
Counter has not come in this case now.